Who invented the telephone? The textbook answer today is Alexander Graham Bell, but at the time of his life, the answer was far less certain. Bell was in fact one of several parties who laid claim to the invention. Their fight for the telephone's patent rights escalated into an unprecedented, near-decade-long legal war that rocked the normally sleepy world of patent law, reached the U.S. Supreme Court, and ultimately shaped one of the nation's longest-lived commercial monopolies. Hello, welcome back to Secondhand History. Today's topic is not exactly how Alexander Graham Bell developed his telephone or whether the credit should go to someone else. Rather, it's primarily about the legal side of it all, the court cases that determined who, in the eyes of the law, would receive the all-important commercial rights to the invention. Still, let's start with the standard invention narrative. An educator of the deaf by trade, Alexander Graham Bell dabbled on the side as an inventor and began work on what would become the telephone in the 1870s. At first, he was simply looking into ways to improve existing telegraph technology by allowing multiple signals to be transferred at once on a single line. But then it occurred to him, if you're going to transfer more and more data on a single wire, why not just cut out the Morse code and try and transfer the human voice itself? The challenge Bell faced here was how to convert the sound waves of the human voice into an electrical signal. Eventually, he came up with an answer: a water transmitter. Basically, it was a crude microphone in which the user's voice caused an electric wire to vibrate in a weakly conductive pool of liquid. This formed an electric current whose internal resistance fluctuated with the wire's depth in the liquid, creating a signal that mirrored the speaker's voice. It wasn't a particularly reliable design, but it was good enough to give to the patent office. On February 14, 1876, Alexander Graham Bell filed a patent for his method of, quote, transmitting vocal or other sounds telegraphically. The patent office granted it the following month. Graham spoke the first words over his new device, and that's where the telephone's origin story typically ends. But oh boy, for the legal system, the story had just begun. Being a successful inventor in 19th century America or Europe wasn't just about creating something new. To make money off of it, you had to legally defend your idea from copycats and competitors, and Bell wasn't the only one toying with how to electrically transmit speech. An impoverished Italian-American inventor named Antonio Meucci filed a patent caveat for a telephone-like device years earlier, but was too poor to finish the process or even pay the $10 renewal fee. Any progress he made was likely lost after he was injured in an 1871 steamship explosion, and his wife reportedly had to pawn off his equipment to pay the medical bills. The term telephone itself was coined by the German inventor Johann Reis for his 1861 invention, but it couldn't transmit intelligible human speech, and he never sought a patent. Most importantly for our story, the American inventor Elisha Gray filed a patent caveat the same day as Bell for an almost identical system, right down to the liquid-based microphone. No sooner than the Bell Company opened for business did rivals begin to produce their own telephones, daring them to sue. It was on. One of the first cases pitted Bell's company against Western Union, a major telegraph company that partnered with Gray to stake its own claim in the new telephone industry. It was a daunting challenge for Bell's startup, but this was where his lawyers played a key move. Western Union went to court expecting the fight to hinge on whether the telephone really brought any new technical innovations to the scene, or was just an amalgamation of existing technology, unworthy of a distinct patent. But to their surprise, Bell's team sidestepped this debate entirely and instead focused on the broader concept of transmitting the human voice via electricity, regardless of the exact process. Western Union's legal team was completely caught off guard. They didn't even know how to respond. Rather than engage in a costly and uncertain legal battle over technology they still saw as a niche novelty, they chose to settle and ceded Western Union's telephone operations to Bell. The victory over Western Union did not transform the Bell Company's fortunes overnight. There were still lots of technical issues related to infrastructure and long-distance transmission, but it allowed the company to shift its aim against smaller, independent operations with fewer resources to defend themselves, and it set a pattern for subsequent court cases. An 1881 ruling cemented the interpretation that Bell's patent covered all transmission of the human voice over electric wires, regardless of the technology used. By this point, Bell himself had sold his share of his namesake company in order to pursue other interests, And the company had long since ditched the unreliable liquid transmitter in favor of microphones based on magnetic induction. But as the Bell Company's wealth grew, so too did the scope and vitriol of the legal cases against it. Its new opponents increasingly challenged the legitimacy of Bell's entire patent. Accusations emerged that Bell stole his initial design from Elisha Gray, allegations that never fully went away. The U.S. Attorney General almost got involved in 1885 and was only dissuaded when the New York Tribune ran an expose revealing that one of the Bell Company's opponents, Pan Electric, had generously gifted him lots of free shares. Finally, in 1888, the U.S. Supreme Court weighed in. By this point, hundreds of cases had transpired, and the arguments before the justices rehashed all their allegations and claims. Stolen documents, corrupt contacts inside the patent office, you name it. One Supreme Court justice recused himself, and another died before the final ruling. Over a year after the initial arguments, the remaining 7 justices issued a 4-3 ruling to uphold Bell's patent, and critically, the interpretation that it covered all electrical transmission of human speech. Although this was not the end of the Bell Company's legal fights, its effective monopoly on the U.S. telephone system had all but received the Supreme Court's blessing. The company, later renamed American Telephone and Telegraph, briefly faced renewed competition when Bell's original patent expired in 1894, but by then it had such a sheer head start in communication infrastructure that it could strangle and swallow rivals just by denying them access to its network until they caved. Its de facto monopoly lasted all the way until 1982, when the U.S. government forcibly broke the company apart. Even today, some of the world's biggest telecom firms trace their roots to the Bell Company's fragments. Of course, one question remains. Was Alexander Graham Bell truly the telephone's rightful inventor? Some popular history books have made compelling arguments that he really might have stolen key ideas from Elisha Gray, but most academic sources remain skeptical. Yet in some ways, this debate misses a larger point. The telephone, like most major inventions, was not a product of a singular eureka moment, but rather the culmination of decades of advances in acoustics and telegraphy. Bell and Gray both built on the same body of knowledge, just as Thomas Edison refined earlier ideas to create a commercially viable light bulb. Inventions rarely emerge in isolation. They are products of collective progress. From this angle, the deeper problem with Bell's patent isn't whether it went to the right person, but how it was used. The way the courts interpreted the patent, it went beyond protecting the original invention and became a legal cudgel the Bell Company used to strike down competition, stifling innovations like automatic switching. The underlying issue shouldn't be who invented what, but whether the broader system that governs innovation serves to encourage it or to hold it back. But what do you think? Let us know in the comments section. Thank you for watching, please like and subscribe, and hope to see you next time. You have nothing to add, Egghead?
No, not this time.
I'm shocked.